Hello, my name is Mike Ryan. The name of the show is Jury Duty, You Make a Difference on BNN, the show that should answer all your questions about the one-day, one-trial jury system. Our special guests today are Kelly Porges, from the Council of Public Counsel Services, and Assistant District Attorney John Pappas from Suffolk County DA's office. Welcome.
Good afternoon.
Thank you for being on the show. And today we'd like to talk about jury selection from both sides, from the prosecution and from the defense. Kelly is a graduate of George Washington University, then went on to work at the Miami-Dade County Public Defender's Office before coming to the committee back in '04. And John has been a prosecutor since 1994, graduate of the University of Massachusetts in Amherst, went to law school at New England School of Law, started at the Boston Municipal Court, then went over to East Boston, became the felony supervisor in 1997, has prosecuted cases with the gang unit, the homicide unit, and in 2011, District Attorney Dan Conley appointed him as chief trial counsel, where you counsel fellow Superior Court prosecutors, yet maintain an active homicide caseload. Yeah. So I guess, first of all, what exactly does a prosecutor do?
Well, we're charged with prosecuting all crimes in Suffolk County, Boston, Chelsea, Revere, and Winthrop. And
from your viewpoint, what does the defense counsel do?
Well, a defense attorney, whether public or private, represents someone who is charged with a crime, whether it's a serious felony like a homicide or something less serious like a trespass case.
And in your instance, these are people who are indigent, people who can't afford an attorney?
My role in the office is to represent anyone who's been charged with a serious felony or a homicide who has been deemed indigent by the court.
Okay, what leads to a case going to a jury?
Well, there has to be someone who's charged, who's arraigned, formal charges have been brought, and I'll answer the question in the context of Superior Court. The case has been investigated, it's been presented to a grand jury, indictments have been returned, and the formal criminal case has commenced in Suffolk Superior Court. There are a number of pretrial dates, discoveries exchanged. There may or may not be discussions to try and resolve the case short of trial. If that happens or doesn't happen, or if the case can't be resolved short of trial, trial date is set and it will commence on the trial date.
What about from the defense side? What leads the case going to a jury?
It's the ultimate decision of the client, whether he or she wants to accept a plea bargain, try to lobby the case with the judge to see what the outcome would be, or if they want to go to trial, either because they maintain their innocence or the case is not very strong against them, so it's their ultimate decision.
Does the prosecution always offer a resolution prior to going to a jury trial?
Not necessarily. There may be discussions. They may be initiated by the Commonwealth. They may be initiated by counsel for the defendant, but I would say it's on a case-by-case basis.
Okay. Do a lot of cases settle just because of the benefit of a jury being in the courthouse?
I think a lot of cases settle because the risk, at least as John said, speaking in Superior Court context, my clients are facing substantial state prison time, and so going to trial is certainly risky even under the best circumstances. So yes, I'd say at least 90%, 80% probably will resolve in some type of plea bargain.
Is that you agree with that?
I don't know. I couldn't put a percentage on it, but the one thing I would agree on is there is that risk analysis that has to take place, given the exposure on a particular case, what the potential penalties are, the strength of the case, and I think those are some of the factors, not all, that go into whether a case is resolved short of trial.
What makes a good juror?
It's completely case dependent. So you might have a homicide case, a rape case, a burglary, an armed robbery, and so obviously anyone's personal experiences, their base of knowledge is going to change from case to case. So it really is an individual basis, which is why the lawyer-conducted voir dire is hugely important, I think, for both sides to make sure we're getting the appropriate jury for the case.
So you've done a few of those trials, that's correct?
I've been fortunate to do a few of them up in Massachusetts and in Florida. They have lawyer-conducted voir dire, so I did it in district court down there. So this is a much larger scale with more serious cases, and it's been much more helpful than I anticipated, frankly.
You've done one with the attorney participating voir dire?
My last trial, correct.
And what was your impressions of it?
I thought it was a huge benefit to both parties, both for the defense and for the prosecution. It gave you a little bit more insight into the person, the actual prospective juror that you were thinking of seating on that jury.
So in most other states, lawyers were always allowed to ask questions of the jury, but in Mass, it was pretty much the judge who would ask the questions of the jurors, correct?
The judge, but prior to this, would ask a series of questions with respect to various constitutional rights, burden of proof, and you could always ask the judge to ask specific questions based on the case, and now it's a more wide forum for us to actually ask the questions, which is a chance for us to kind of talk back and forth with the juror, which is, again, helpful for both sides, I think.
Do you find that it enhances the voir dire process?
It does, and it doesn't take longer than jury selection took before. So I think it's definitely, it benefits everyone. And
same thing with yourself, John, you think that it...
Right. You know, the judges still ask the constitutional questions, but they give each attorney an opportunity to ask some additional follow-up questions. Usually the parameters of what those follow-up questions are set beforehand, but it gives the attorneys, both parties, an opportunity to interact with the jurors.
What was your longest jury trial?
Probably 3 to 4 weeks when you're talking a murder case.
3 to 4 weeks, and for you, Mr. Prosecutor?
Right about the same, 4 weeks.
About the same, that's about the longest one. Have you ever gone to jury duty?
I was called once, and it was a civil case, and I was immediately excused.
But you went, that was the important thing.
Yes.
John, yourself?
I think it was right before I started law school. It was in Suffolk Superior Court. I was actually picked, seated on the jury, civil case. Probably about 2 witnesses in, the case settled.
So
Personal injury case.
But you haven't sat on a trial?
No, I have not.
Okay, but that's great that you went, and we've even had judges, you know, sit as jurors on criminal cases. Have you ever been surprised by a jury verdict?
Oh, sure.
And do you sort of, when you go out to deliberate, you have any feeling at all, or you just flip a coin, or?
I think it depends. I mean,
the
longer I do this, the more I think I know, but it's really the less you know, because juries, they're people just like you and I, and they have their own ideas and their own opinions, and sometimes they'll sink their teeth into something neither side brought up, and they'll come back with a verdict that surprises you. Even if you think it's the right verdict, you're surprised, and I'm sure it goes the same for John.
I'm not sure I'd say necessarily surprised. In the context of homicides, which I did for a number of years, those cases are so well vetted, so well prepared by the time they go. I think at that point you have a very good idea what the strength of your case is. You may be disappointed in a verdict, but I don't think I've been necessarily surprised.
Now, lawyers are allowed to challenge some of the jurors, known as a peremptory challenge. Is there any science to picking jurors?
So you have 2 types of challenges. You have cause challenges, and that's when there's something specific about a juror that makes them inappropriate for a case. For example, if you're trying a case in Suffolk County and a prospective juror comes up and he's a Boston police officer, you might challenge him for cause because he's going to be listening to testimony by his colleagues, and can he remain impartial? Or you might have a peremptory charge, and that can be based on a feeling you get. I mean, with me, if a juror smiles at me and seems friendly, they're a good juror. But sometimes they'll scowl, they'll look at my client with evil eyes, they're shaking, they're uncomfortable, and you just get a bad feeling. And so you bounce them off.
How about you when it comes to selecting jurors?
Well, if
do you worry about the evil eye, like
don't.
Kelly does?
No. If there's a science, I would say it's a very inexact one. I think at the end of the day, after you've done enough of these cases and have gone through the process a number of times, I think at the end of the day, what you're really looking for is the person attentive? Do they bring any biases with them into the courtroom? And at the end of the day, can they judge the case? Can they be a fair and impartial juror and judge the case based on the evidence that's presented in the courtroom?
And in some places, they talk about getting rid of peremptory challenges. Should they? Should they still be part of the process?
I absolutely think they should. Because I think, I mean, John and I are both been doing it. I mean, obviously John a lot longer, but there's certainly jurors that prosecutors want on cases and don't want on cases, and vice versa with the defense. We want people who are open-minded, generally who are going to not just jump to conclusions and hear horrible allegations and just blindly believe whether it's police officers or civilian witnesses. And so we're both looking for specific jurors. It's not uncommon when I'm picking a jury that I like a juror and I can already anticipate my opponent is going to ask them to be removed, and vice versa. So I think it is an important component.
I think the process has worked extremely well and is time proven. I think it's very important for each party to have the same number of challenges, to exercise those challenges as they see fit. So you're not left with taking, the first 16 citizens who are declared fair and impartial by the judge or indifferent by the judge after the preliminary rounds of questions. And it's a process that's worked, it continues to work, and it will work for the foreseeable future.
Should anybody be upset if they're peremptory challenged? When people are told they're challenged, they're told to step out of the box and maybe go back to the jury pool, or they're gone for the day, but should they take it personally?
I don't think anyone should ever take that personally, and I think probably, the reality is if you were to poll those people who got excused, they probably would be happy that they got excused. So, no, the answer is no.
Same.
I agree.
Okay. Are some cases in this day and age with advances in technology, are some cases too complex for jurors?
Absolutely not. I think it's our job as attorneys to explain whether it's science or some psychological issue that's being raised. It's our job to explain that to the jury. I mean, John and I aren't scientists, doctors, professors, we're attorneys, and so if we can digest the material and present it in a way that the jury can understand it, then they're certainly able to sit as jurors and make a decision.
Same with you?
Yeah, certainly there are cases that can be complicated on two fronts. They can be complicated factually, and there can be certain aspects of the evidence in a case that can be complicated. But like Kelly said, it's an attorney's job to present the case in a way that the jury is going to understand it the first time they hear it.
So, in other words, it's the attorney's job, if it's complex, or as you say, maybe it's heavy on facts and details, to bring it down to layman's terms?
That's in a light most favorable to your side, to be honest, too.
Okay, I get that. Now, do we really need judges if we have, excuse me, do we really need, that's good, do we really need jurors when we have judges who are trained in the law? Do we need jurors to decide cases?
I think absolutely you do. This is our system. It's the jury system is the bedrock of the criminal justice system, to go before your peers and to be judged. I can't see a different system or a better system.
I agree. I couldn't say it better. It's to go to just a judge. It shouldn't be one person. It should be a group of your peers that makes the decision.
What about, you hear about jury consultants? I mean, is there a science to picking people to sit on a jury?
I've heard about them. I know our office has made use of them on a couple of cases. I've never had the experience or had a case where we employed a jury consultant, so I'm probably not a good authority to ask on that particular subject, but I imagine they do have a certain utility, that they're useful in some way. My understanding is that they may hear portions of a case, and you'll get feedback from what's known as a focus group, and how they receive certain pieces of evidence or what they feel about certain parts of a case.
What do you think about jury consultants?
Along with John, we haven't had the opportunity to use them. I know private attorneys who have done full jury trials in front of jury consultants, and I know they find it helpful, but I think it's more helpful just by them vetting out different issues that you didn't think of, where it is more like a focus group. But I think we can do that with colleagues and friends and families. And
so there is no exact science to picking. Nobody's an expert on picking a jury.
I think the more you do it, the more experience you get. But just being a human being and talking to people every day makes you a good person to pick a jury, I think, because it is just getting to know someone. And again, John and I probably want very different people on different juries, so we might have differences of opinions on that, but just someone who has an open mind who's going to listen.
Is serving on a jury a good way to learn about the court system?
Oh, I absolutely think it is. I mean, we have so many different Law and Order shows and legal shows that flood the airwaves on cable. And in the criminal context, you have the incident, investigation, and trial, and it takes place probably taking out the commercials in about 50 minutes. Mm-hmm. Very few people have an understanding of the mechanics of a full-blown jury trial, and I think it's, you know, an absolutely it's an educational thing for a juror to go through it. I can recall on a number of occasions where the judge has gone up to speak to prospective jurors or jurors, deliberating jurors after a case is concluded, in their, I wouldn't call it fascination, but their appreciation for all the hard work that goes into putting on a case, not just by the prosecution, but by the defense, by the judges, the staff of the courtroom, by all the parties who come in. And I think it's a real eye-opener for people who get to sit and deliberate on a criminal case.
Do you feel the same way? This is a great learning experience for the average citizen?
Oh, I definitely agree. I think what always amazes me is juries really listen to the jury instructions, and I think presumption of innocence and reasonable doubt and your right against self-incrimination, I think it becomes very powerful, and you can see their faces when they listen to it. And so I think they hear about it or have history class growing up, but they really learn what it is like, and that these rights are important and the system should work, and that they feel like a really important part of the system, and they take their job very serious. And again, that always surprises me, how they really want to look at all the evidence and take their time and not just jump to conclusions.
Now, you've worked in the district courts, and when jurors are checked in, they pass in their confidential questionnaire, they're welcomed by a judge, they watch a movie. A lot of times they're waiting. So while they're waiting, you know, sometimes they get a little impatient. But what goes on in the courtroom while they're down in the jury pool?
Well, it depends. A lot of times what can be taking place upstairs in the courtroom are the final preliminary matters. In any criminal case, there are usually motions in limine that have to be addressed before jury selection begins. You might be fine-tuning, or the court might be fine-tuning the final questions that are going to be posed to the jurors when they come in. So there are all those little housekeeping matters that are taking place right before the jurors are actually brought up.
And you find the same way that the jurors, while they're waiting, there's things going on in the courtroom that they have no knowledge about, no access about.
Exactly, and we promise you we're not, you know, having coffee and donuts and hanging out. It really is, we want to make sure that when we do bring them into the courtroom that we're ready to pick them and start the trial. And so there are housekeeping issues that need to be addressed, and we definitely do that.
And so like in the BMC or the district court, usually there's a first call of the list?
Well, way back when I was at the Boston Municipal Court, there'd be the call of the list in the trial assignment session, and those cases that were ready for trial would get sent out to the trial sessions. And I think back then there were 2 trial sessions where, you know, the judges would be waiting. There'd be a prosecutor, defense counsel. Actually, they might start in the assignment session, but then head down to the trial sessions. And from that point, they'd bring up jurors after they decided which cases were actually going to go, because there would probably still be some discussion potentially on resolving the case. Short of trial, if that couldn't happen and there were enough jurors, they'd bring up the jurors and the trial would get underway.
And sometimes there's a second call of the list as well, and then they weed out some of the cases during the first call, and then later there might be a second call to see what's happening with the rest of them?
Sure. Back then, you know, in the district court context, there could be multiple calls, and you know, multiple cases could get sent down to a trial session. Obviously, you can only accommodate one trial, so the cases that couldn't get resolved that day, the one would go, they'd bring up jurors for that particular case, and the other ones, if they didn't resolve, would get sent back to the trial assignment session to get a new trial date.
Sometimes jurors, when they've finished their service and they've not gone into a courtroom and they're willing to sit on a trial, they feel that their time is wasted. Should they ever feel that way?
I can completely understand that feeling. I mean, they're taken away from their job, from their children, from commitments, and some trials can go up to a month, if not longer. And so it is a huge responsibility, and it's one that myself as an attorney and as a citizen appreciate. And I think the judges do a nice job at reminding them how it is important, and how if you or a family or friend was ever in this position on either side of the fence, that you would want a juror who is going to be respectful and pay attention and really be invested in their role. So we completely understand their time, and we try to give them a really good estimate of how long we think the trial is going to be. Courts have always been good about vacations, family vacations, even work vacations. We don't want anyone to lose out on some experience like that, but everyone does have a responsibility, and we certainly appreciate them sitting there.
So the same thing, if some jurors are mad because they actually wanted to sit on a case, but because of what transpired in the courtroom, that case may have settled.
Yeah, and as far as a case going along, I can say this. The judges are so conscientious in their preliminary questions. You know, without exception, it's been asked in every case I've ever handled that's gone to trial. The judges always are pretty tough on the attorneys, asking them, how long do you anticipate the trial is going to go? And the attorneys usually, who are very experienced doing those types of cases, have a very good sense. It's going to be, you know, 4 to 5 trial days, or 5 to 6, 5 to 7 after impanelment. That's the actual trial. So that doesn't include impanelment. That doesn't include deliberation. So the judges always, in their preliminary questions to the jurors, tell them that what they estimate the length of the trial to be. And after they put out that estimate, they ask if that's going to pose a hardship to anyone. So anyone who's really going to have a hardship, they have an opportunity to raise their hand, go up to the judge and explain why this would be a hardship to them. If the judge is satisfied, they'll excuse the juror, and what you have left is people who have heard the approximate length of the trial, are still willing to stay, and I think you eliminate a lot of problems that way.
So you encourage everybody to go to jury duty?
Absolutely. I'm sure it's maybe more fascinating or exciting for someone like John or I, because this is our passion, our love, what we do, and so it's interesting to us. But it is, as much as it's a responsibility, I think it's also a privilege to be part of history. This is your constitutional rights. It's your right to be there. You have a right to hear this evidence, to make a decision, because it's your community. And so I think if you're not going to participate and go to jury duty, then you can't complain about what's going on around you or the system, because, again, we know that even one day out of your life is hard. One day out of my life or John's, I'm sure, is hard. But if anything, people who are designated as alternates seem to be very upset because they've sat through the trial, they've become invested, and then they're not allowed to participate in the decision-making process. So if anything, that's where I've seen frustration. Once a juror gets sat, they've kind of just been like, okay, they've resolved to it, and then they get invested. So
jury duty, as you mentioned, the bedrock of democracy?
It is. It's once every 3 years. Don't miss it.
Right.
Well, we've run out of time. We'd like to thank you for joining us today on Jury Duty Make a Difference on BNN. Just remember, if you have any questions about your jury service, you can always contact the Office of Jury Commissioner online at majury.gov, or call us toll-free at 1-800-THE-JURY. That's 1-800-843-5879. You do make a difference. Please serve when called. It's important to all of us. Thank you, Kelly.
Thank you.
Thank you, John.
Thanks, Mike.
And thank you at home.